Question number 651. It appears to the court that the evidence of Mr. X, a person confined in prison outside the state, is material in a suit. The court may, option A, make an order requiring the district magistrate in charge of the district to produce that person before the court to give evidence. Option B, make an order requiring DGP of the state in charge of the prison to produce that person before the court to give evidence. C, make an order requiring the officer in charge of the prison to produce that person before the court to give evidence. And option D, constitute a commission to record the statement. Here in question number 651, correct answer is option C, that is make an order requiring the officer in charge of the prison to produce that person before the court to give evidence. Question number 652. Under proviso to sub rule 1 of order 17 of the CPC, maximum adjournments can be granted are option A 5, B 4, C 3 and D 2. Here correct answer is option C, that is 3. Question number 653. Which of the following is not a sufficient cause for granting adjournments? Option A, sickness of a party, his witness or his counsel. B, non-examination of a witness present in the court, non-service of summons, reasonable time for the preparation of a case. Here correct answer is option D, reasonable time for the preparation of case is not a sufficient cause for granting adjournment. Question number 654. An adjournment shall not be granted on the ground, option A, where the circumstances are beyond the control of that party, pleader is ill and a party could not engage another pleader in time, the pleader of a party engaged in another court, both where the circumstances are beyond the control of that party and pleader is ill and a party could not engage another pleader in time. Here correct answer is option C, the pleader of a party engaged in another court is not a ground on which an adjournment can be granted. Here option C is the right answer. Question number 655. Dismissal of a suit by a court under order 17 rule 3 of CPC. Only remedy available to plaintiff is to file an appeal, application under section 151 CPC, application under order 9 rule 9 of CPC, and option D, all of these. Here correct answer is option A, that is an appeal. Question number 656. Hearing of the suit and examination of a witness is covered under order dash of the CPC. Here correct answer is option A, under order 18 of CPC. Question number 657. Under order 18, who has right to produce evidence first? Option A, none of these, plaintiff, defendant, both plaintiff and defendant. Correct answer here is option B, that is plaintiff. Under order 18, plaintiff has the right to produce evidence first. Question number 658. In every case, the examination in chief shall be on affidavit orally by typing in his court as court thinks fit. Correct answer here is option A, that is on affidavit. Question number 659. Which one of the following orders or rules under the CPC provide that in every case of the examination in chief of a witness shall be on affidavit? Here correct answer is option A, that is under order 18 rule 4 clause 1. Question number 660. Order 18 rule 4 clause 1 of CPC, the examination in chief of a witness shall be recorded. Option A, by the judge, option B, by the commissioner appointed by the court, on affidavit, all of the above. Here correct answer is option C, that is on affidavit. Under order 18 rule 4 clause 1 of CPC, the examination in chief of a witness shall be recorded on affidavit. Question number 661. What is not correct about the recording of evidence under order 18 rule 4 of CPC? Option A, the examination chief of a witness shall be on affidavit. Option B, for cross examination the commissioner shall be appointed. Option C, the district judge shall prepare panel of commissioners to record the evidence. And D, the admissibility of a document which are filed along with the affidavit shall be determined by the commissioner. In question number 661, incorrect option has been asked. Here option D is incorrect, that is the admissibility of document which are filed along with affidavit shall be determined by the commissioner is incorrect. Therefore it will be the right answer. Whereas other options, the examination chief of witness shall be an affidavit is correct. For cross examination the commissioner shall be appointed is also correct, and the district judge shall prepare a panel of commissioners to record the evidence is also correct. Question number 662. A witness who has already been examined can be recalled under order 18 rule 17 of CPC. Correct answer here is option C, that is by the court. Question number 663. When English is not the language of the court, evidence may be taken in English if the court considers is necessary, all the parties do not object, both A and B, none of the above. Correct answer is option B, that is all the parties do not object. Question number 664. The commissioner is appointed under the provisions of order 18 of the CPC for the purpose of recording of evidence cannot re-examine a witness, decide objections raised during the recording of evidence, neither of the above, both A and B. Correct answer here is option B, that is decide objections raised during the proceedings recording of evidence. Question number 665. Which one of the following provision of CPC is related to affidavit? Here correct answer is option B. Order 19 is related to affidavit. Question number 666. Which order empowers the court to make order that any particular fact may be proved by affidavits? Order 10, Order 11, Order 16, Order 19. Correct answer here is option D, that is Order 19. Question number 667. Which of the following is true? Affidavits can be confined only to statements of knowledge. Affidavits can be confined only to the statements of beliefs. Affidavits cannot be confined to the statements of belief only on interlocutory applications. None of the above. Here correct answer is option A. Affidavits can be confined only to the statements of knowledge is true. Question number 668. Judgment and decree have been dealt in which of the following order in CPC? Option A, Order 20, option B, Order 19, option C, Order 20A, option D, Order 21. Correct answer here is option A, that is Order 20 of CPC. Question number 669. Copy of judgment shall be made available to the parties under Order 20, Rule 1, Clause 2 of CPC. Option A, immediately after the pronouncement of the judgment, after 7 days from the pronouncement of the judgment, after 14 days from the pronouncement of the judgment, after 21 days from the pronouncement of the judgment. Here correct answer is option A, that is immediately after the pronouncement of the judgment. Copy of judgment shall be available to the parties under Order 20, Rule 1, Clause 2 of CPC immediately after the pronouncement of judgment. Question number 670. After completion of the trial, the judge pronounced the judgment but did not sign the decree and he is transferred. Then option A, the decree prepared can be signed by the newly posted judge. The decree prepared is sent for the approval of the High Court. The decree is sent for signature to the court to which the trial court subordinate. The new judge has to rehear the arguments in the suit. In question number 670, correct answer is option A. The decree prepared can be signed by the newly posted judge. Question number 671. What is the maximum time granted by the court by CPC to draw up a decree after pronouncing judgment? Here correct answer is option A, that is 15 days. 15 days is the maximum time granted by the court to draw up a decree after pronouncing judgment. Question number 672. According to Order 20, Rule 7 of CPC, the decree shall bear the date of the day on which the judgment was pronounced, the day on which the decree was made, the day on which the plaint was filed, the day on which the final argument was heard. Here correct answer is option A, that is the day on which the judgment was pronounced. Question number 673. Under which provision decreed amount may be directed for the payment in installments after passing the decree? Here options are Rule 10, Order 20 of CPC, Rule 11, Order 20 of CPC, Rule 12, Order 20 of CPC, Rule 10 of Order 21 of CPC. Correct answer here is option B, that is Order 20 and Rule 11 of CPC. Question number 674. Order 20, Rule 12 of CPC provides for passing of preliminary decree in a suit for dissolution of partnership, preemption, possession and mesne profit, accounts between principal and agents. Here correct answer is option C, that is possession and mesne profits. Question number 675. After passing a decree for payments of money on the application of the judgment debtor, the court shall not order that payment of the amount of decree shall made by installments. Option A, without recording evidence of both parties, without obtaining affidavits from both parties. C, without obtaining the documents regarding the financial condition of the judgment debtor, without consent of the decree holder. In question number 675, correct answer is option D, that is without the consent of the decree holder. Question number 676. Preliminary decree can be passed in a suit for partition, for partnership, for possession and mesne profit, all of the above. Here correct answer is option D, all of the above. Question number 677. In which of the following suits CPC provides for the passing of preliminary decree? Suits for preemption, suits for possession and mesne profits, administration suits, all of the above. Correct answer here is option D, that is all of the above. Question number 678. Order 21 of CPC dealing with execution of decree and orders contains is 106 rules. Option D here is the right answer. Question number 679. Largest order of the CPC is Order 21. Option B here is the right answer. Question number 680. When a court desires that its decree shall be executed by the another court, it shall send to the other court a decree and certificate of non-satisfaction, judgment and decree, judgment and execution petition and certificate of non-satisfaction. Correct answer here is option A, that is a decree and a certificate of non-satisfaction. Question number 681. Where execution is applied within dash years of the decree, issuance of notice of the application for execution of a decree to the judgment debtor is not necessary. Option A, 2 years of the decree, 4 years of the decree, 3 years of the decree, 5 years of the decree. Here correct answer is option A, that is 2 years of decree. Where the execution is applied within 2 years of the decree, issuance of notice of the application for execution of decree to the judgment debtor is not necessary. Question number 682. Under which provision of CPC, execution of decree for a specific performance or restitution of conjugal rights or for an injunction is provided? Here options are Order 21 Rule 30, Order 21 Rule 31, option C Order 21 Rule 32, option D Order 21 Rule 34. Correct answer here is option C, that is Order 21 Rule 32 of CPC. Question number 683. A decree for restitution of conjugal rights can be executed under Order 21 CPC by detention in civil prison, either by the detention in civil prison or attachment of property. Detention in civil prison and attachment of property, attachment of property. Here correct answer is option D, that is attachment of property. Question number 684. Under Order 21 Rule 37 of CPC, before arrest and detention it is mandatory to issue show cause notice. Option B, in the absolute decision of the court whether to issue show cause notice or not, no show cause notice is required. Mandatory for the executing court to issue show cause notice only if the execution is applied after 2 years of the decree. Here correct answer is option A, that is mandatory to issue show cause notice. Under Order 21 Rule 37 of CPC, before arrest and detention it is mandatory to issue show cause notice. Question number 685. Under Order 21 Rule 37, before passing an order for the arrest and detention in the civil prison of the judgment debtor, court, option A, shall issue show cause notice instead of warrant for the arrest, may issue warrant of arrest if it is shown on the affidavit that the judgment debtor is about to abscond. C, shall issue attachment warrant before arrest warrant, and D, option 1 and 2 are correct. Here correct answer is option D, that is option 1 and 2 are correct. A and B option A here are correct, that is shall issue show cause notice instead of warrant for arrest, may issue warrant of arrest if it is shown on the affidavit that judgment debtor is about to abscond. Question number 686. Which of the following provisions of CPC provides for the adjudication of claims and objections for the attachment of property? Option A, Order 21 Rule 59, B, Order 21 Rule 58, C, Order 21 Rule 57, and none of the above. Correct answer here is option B, that is Order 21 Rule 58 of CPC provides provisions for the adjudication of claims and objections to attachment of property. Question number 687. Auction purchaser shall pay full of purchase money. Option A, within 7 days, within 15 days, within 21 days, within 30 days. Correct answer here is option B, that is within 15 days. Auction purchaser shall pay full of purchase money within 15 days. Question number 688. Time prescribed for filing of which of the applications cannot be extended or condoned by applying provisions of the Section 5 of Limitation Act. Option A, revision under Section 115 of CPC, application for execution under Order 21 of CPC, appeal under Section 96, 100 and 104 CPC, application for substitution under Order 22 of CPC. Here correct answer is option B, that is application for execution under Order 21 CPC. Time prescribed for filing cannot be extended or condoned by the applying of provisions of Section 5 of Limitation for application for execution under Order 21 CPC. Question number 689. Which of the following persons may not file an application for execution under CPC, namely a decree holder, legal representative if the decree holder is dead, a person claiming under decree holder, judgment debtor. Here correct answer is option D, judgment debtor is the person who may not file an application for execution under CPC. Question number 690. Where immovable property forms one estate situate within the local limits of the jurisdiction of 2 or more courts. Option A, any one court may sell the entire estate. The court can sell only that part which is within its jurisdiction. C, none of the courts can sell any part of the estate. D, the court can sell the entire estate within whose jurisdiction majority portion of the property is situated. Here correct answer is option A, that is any one court may sell the entire estate. Question number 691. Garnishee is a person who is defaulter, decree holder, debtor of the judgment debtor, foreigner. Here correct answer is option C, that is debtor of the judgment debtor. Garnishee is a person who is debtor of judgment debtor. Question number 692. Garnishee order is an order prohibiting the judgment debtor's debtor from making any payment to the judgment debtor, directing the decree holder to take the payment from the judgment debtor's debtor, both A and B, none of the above. Here correct answer is option C, both A and B. A garnishee order is an order prohibiting the judgment debtor from making any payment to the judgment debtor, directing the decree holder to make payment from the judgment debtor. Question number 693. Garnishee proceedings under CPC can be instituted to enable option A, attachment of debt, shares and other property not in possession of the judgment debtor, attachment of property of which the owner is not known, only for the attachment of property which cannot be estimated in terms of money, only for attachment of a share in joint family property. Here correct answer is option A. Garnishee order under the CPC can be instituted to enable attachment of debts, share and other properties not in possession of the judgment debtor. Option A here is the right answer. Question number 694. Which of the following statement is correct? Option A. An attachment order may come to an end by A, satisfaction of decree, B, setting aside or reversal of decree, C, dismissal of the execution application for decree holder's default, D, death of the decree holder, and E, agreement compromise between the parties. Select the correct answer by using the code given below. Here correct answer is option A. A, B, C and E. Except D, all the other options are correct. I am repeating option again. An attachment order may come to an end by satisfaction of decree, setting aside reversal of decree, dismissal of the execution application for decree holder's default, death of the decree will not abate the suit, and E, agreement compromise between the parties is also correct. Here option A is the correct answer. Question number 695. X obtains money decree against Y. In execution of the money decree, X attaches monies belonging to Y lying with Z. Then Z is called decree holder, judgment debtor, banker, garnishee. Correct answer here is option D, that is garnishee. X obtains money decree against Y. In execution of money decree, X attaches monies belonging to Y. Y is lying with Z. Then Z is called garnishee. Question number 696. A holds a decree against B for rupees 5,000. B holds a decree against A for rupees 3,000. Both A and B apply for execution of decree to a court which has jurisdiction to execute both decrees. The court may allow execution of A's decree of rupees 2,000, simultaneously proceed with the execution of both decrees. B shall proceed separately with his decree, none of these. Here correct answer is option A. Allow execution of A's decree of rupees 2,000. Question number 697. Which one is not correctly matched? Institution of suit, order 4. Judgment and decree, order 20. Issue of summons, order 5. Issue of commissions, order 21. This is not correctly matched. Order 21 is related to execution. Question number 698. Which among the following is not correct relation to consideration of order 21 rule 90? Here options are: there must be a material irregularity or fraud in publishing of the conducting of sale. It must relate to conduct of sales alone. C, the applicant must have sustained substantial injury. D, such injury must have been caused by the material irregularity or fraud. Here correct answer is option B. In this question it has been asked which of the following is not correct in relation to consideration of order 21 rule 90. Option B here is not correct, that is it must relate to conduct for sale alone is not correct, therefore it will be the right answer. Other options are correct, that is there must be a material irregularity of fraud in publishing or condoning conducting of sale. The applicant must have sustained substantial injury, and such injury must have been caused by the material irregularity or fraud. Question number 699. In execution proceeding before trial court, a person filed application under order 21 rule 97 CPC on ground that he was bona fide purchaser of suit property. His objection: maintainable because he has bona fide purchaser. B, is not maintainable because his lis pendens prohibits a party from dealing with property which is the subject matter of the suit. C, maintainable because he has not filed independent suit. D, can be heard only if the parties permit. Here correct answer is option B. Is not maintainable because his lis pendens prohibits a party from dealing with property which is the subject matter of suit. Question number 700. Proceedings in the CPC include proceeding for the execution of a decree or order, proceeding for the execution of a decree, order, or the prosecution order for a prosecution. Here correct answer is option A, that is first is correct. Under CPC, a proceeding for the execution of decree or order is provided.